Good afternoon, everyone. My name is Joe Ryder, and welcome to the National Apartment Association's second installment of our resident screening for property management resource series, entitled What to Watch For: Applicant Screening Trends for Property Management to Master. I am the Senior Manager at NAA's Public Policy Team, and I will be your host. Before we get started, I'd like to cover a few table setting matters. First, we will be circulating a video recording and copy of the slide deck to all registrants for the webinar in the coming days. Second, today's Q&A will not be recorded, so you will have an opportunity to ask questions candidly. Additionally, we are offering this member benefit as part of NAA's Fair Housing Month offerings, intended to support our members in their work to ensure fair housing compliance. For those interested in learning more about fair housing regulations, NAA offers a fair housing professional program through Visto. A link to the program will be available in the chat. Today, you will hear from our expert speaker on trends in the resident screening space that you as property management professionals can apply in your daily work. To that end, this webinar will provide clarification for site-level professionals to better understand the regulatory frameworks that govern resident screening practices. The goal is to assist you in operationalizing your compliance practices to maximize efficiency and reduce compliance costs. So we've turned to the antitrust compliance slide. Before we get to introducing our expert speaker, I'd like you to all take a brief moment to review and familiarize yourself with NAA's antitrust compliance statement and legal disclaimers. Thank you. Next slide, please. Alrighty, please join me in welcoming our distinguished expert, Mr. Jay Harris. He is a partner at Hudson Cook, where he leads the residential property management practice and counsels rental housing providers and suppliers. Previously, Attorney Harris has served as general counsel to National Rental Housing Suppliers and vice president of property management for the National Apartment Association and National Multifamily Housing Council. Welcome, Jay.
Thanks, Joe. Appreciate your having me back for this kickoff presentation in Fair Housing Month by National Apartment Association. We're going to talk about property management issues and background screening from the perspective of operators that are operating in multiple states, because typically the challenges we see today are understanding some of the trends that are implemented differently depending on what city, what state you're operating in, but there are definitely some common themes. And that's, given the 45 minutes or so that we have today, that's where we're going to focus on how to manage this if you have a multi-state portfolio. So to get going here, the themes on the next slide that we've talked about some new guidance coming from for the federal agencies that have a say in tenant screening and the accuracy of consumer reports. Talk about the proliferation of local rules and how that impacts the tenant screening process. Talk about the significant growth in applicant fraud and things to keep in mind in fighting fraud in the application process. Talk about some of the local variations in credit and income qualification, including credit scores or the use or non-use of those, depending on the situation. Talk about public records, both rental history and criminal history records and use in screening. Talk about a newish trend of portable reports, where a consumer is bringing to the housing provider their own report, and what to think about in several states that encourage that kind of background screening solution. Talk about disputes and reinvestigations, where there's information that a housing provider may have reported about payment information and the role of the housing provider, where a consumer reporting agency may come back and say, hey, we need some help in verifying information you reported about amount that was owed to you because it's showing up in the screening process at another property or a credit application that a ex-resident is involved in. And then finally, we see, so at Hudson Cook, we represent both on a compliance basis and on a litigation basis, housing providers as well as vendors in this space. And there are a couple themes that we wanted to touch on and emphasize to improve understanding on both sides, make sure swim lanes are understood, roles are understood. And so we'll close by talking about that area. So with that, let's jump into some of the new guidance from about 2 weeks ago now from four of the federal agencies on tenant background checks. This is from the Federal Trade Commission, the Consumer Financial Protection Bureau, whose roles and responsibilities for regulatory guidance and enforcement focus on background checks and the consumer reports involved in them. HUD with its obligations and DOJ with their obligations under the Fair Housing Act and enforcement authority in that space, as well as under HUD programs. And I guess the punchline here in reviewing this new guidance, the first time that these four agencies have gotten together to create a guidance document such as this. But it's a good roadmap, I would say, for reviewing how a housing provider would respond to these kinds of questions from an applicant. It does not break a lot of new ground, but it does put in one place and for a rental applicant information about what to do in the tenant screening process. So it's timely and a good place for us to start. The document, which is available online under this tenant background checks and your rights, is really, as I mentioned, for the perspective of the renter or applicant. It describes where they can complain if they feel that in the background screening process, the applicant has not had accurate information about them provided, has information that in the decision process they wish to appeal or try to change the result of the housing provider. So they start by identifying both agencies where a consumer can complain, as well as attorneys, other advocacy organizations on behalf of tenants that are resources for residents in this area. The guidance then goes to talk about before you apply, what a consumer should keep in mind, giving the full name in the application process, which can be a source of missed or mismatched names from time to time, particularly with common names. So good advice for all of us in that score. Understanding the fee that will be charged, and then asking the housing provider what sort of information is used in the process of the screening process. So these are all things that you may get questions about as a housing provider based on this guidance. In particular, I think there's more attention by the federal agencies in creating awareness of the criteria that a housing provider uses before the consumer applies, so that they can understand and be aware before they put down an application fee and go through the effort of applying, if they have derogatory credit history, derogatory rental history, or significant problems with criminal history, such that they can know early in the process before they apply whether they would qualify under the housing provider's criteria or not. So that talks about before the consumer applies. If the landlord makes a negative decision, it's addressing here the adverse action obligations. There's nothing new, but sometimes it is new to some, to understand that where a consumer report is used in the screening process to decline an individual, an adverse action notice is required. That's pretty well understood. Some providers sometimes don't always appreciate that even where the rent is increased or a guarantor is required for an applicant, or the deposit is increased as a result of marginal consumer history, typically credit history, this too is an adverse action that triggers an obligation on the housing provider to deliver the adverse action notice. So that's not new. That's something the Federal Trade Commission was talking about 30 years ago, but it is something to keep in mind as you review the process for communicating to a consumer, even when they've been accepted to rent. There's been some recent attention by the federal agencies over a written or electronic adverse action notice as a best practice. Increasingly, as we'll talk about on the next slide, there are local rights that localities expect that a housing provider will include in the adverse action notice. So this notice is not a one-size-fits-all federal solution. There are models out there, but typically it's the responsibility of the housing provider to make sure they're using the right adverse action notice with the right local appeal rights and so forth in that jurisdiction. And then finally, where the housing provider is making a negative decision, taking adverse action, tenants encouraged to get a copy of the background check that was used and to dispute any errors that may be in the report, whether it's credit, criminal history, rental history, or a reference check with a prior housing provider. For the first time, this new guidance recognizes that there's more attention to what courts are doing and how quickly they will update records. Increasingly, we hear stories about states that are moving clean slate legislation to automatically expunge or seal public records, typically criminal history records, but also eviction records. And so here, consumers are being encouraged to check with their the housing court or even the criminal history they have with the court to make sure that it accurately reflects the status that they believe. And where possible, as these rights grow, consumers, renters have greater rights to seal prior eviction records. And so they're encouraged to seal your records if possible by the federal agencies in this new guidance. The right to be free from discrimination, HUD, DOJ, in this guidance, there's nothing new in that area. This guidance document finishes with a long list of sources of help for consumers to contact where they suspect discrimination or if they have questions about how to correct a screening report. So this is a useful tool. It's good to familiarize yourself with, use potentially in the training process to understand where the applicant may be coming from and what they're asking you for, where there's an individual who may have been declined, but it seeks to dispute or correct a record that was used by your firm in the process. So a useful tool. Let's move on to the next slide. And here we'll talk about the growing patchwork of local rules, a theme that we'll touch on a couple other slides, but we're starting here with the screening life cycle and talking about even before the consumer is applying. These are disclosures, pre-screening disclosures that are expected by a wider and wider set of states and localities. There are caps on fees for application and or background screening, and then requirements to provide a receipt that some states are requiring in the screening process. Again, as a law firm that spends some time in this area, one of the key situations we see is where a property operator is entering a new state and may not be up to speed on some of the local variations that may change their process. So while some operators are pretty savvy about states that they've been operating in for a while, entering a new state may trigger some new changes to the application screening flow for your own operations and for the way that your vendor facilitates this. So the types of things that are in pre-application disclosures often, as I mentioned, are the screening criteria that are used at the property, a high-level description of the credit, rental history, criminal history that is or is not qualifying, and maybe the use of guarantors in the process for a conditional acceptance. But increasingly, we see that states and localities are asking that these disclosures include local rights, such as a right to appeal a decision made by a housing provider, or even more detail about what kind of units are available, at what sort of rents, in disclosures that are needed in jurisdictions from Utah to Washington, D.C. California has long had an obligation to provide to the consumer a checkbox, giving them the option to receive a copy of the report that the housing provider uses right when they apply. And similarly, a notice of the rights of the consumer to access a file that may be maintained about them with their information with the consumer reporting agency. Colorado is one which expands the pre-application disclosure to also disclose how the housing provider will handle what its policy is for handling a portable report brought by the consumer to the property. So these are a flavor of the kinds of pre-application disclosures that are expected. And they become increasingly important as vendors facilitate this in the online screening process. More consumers are using an online screening process. But housing providers really want to make sure, as between them and the vendor, that these local requirements are being followed appropriately. Fees, the limits of these are typically governed by state law. The Biden administration has spent a lot of time talking about unreasonable fees or junk fees, and they've been encouraging the states to enact legislation in this space, and that has led to some states last year and currently this year, NAA involved in fee disclosure and fee reasonableness legislation in states around the country through NAA and its affiliates. So it's important to stay on top of any new caps on fees that are passed in a particular jurisdiction. I think one thing to watch for jurisdictions where the consumer has the right to bring a portable report, in this case, that the application fee may not be charged, or a situation where there's a repeat application from one property to another property by the same consumer to the same housing provider. In some cases, the fee can't be charged for that second application in a state like Oregon. So again, these are just dimensions of the kinds of state and local variations that are required in order to comply. One resource I wanted to point out, make sure it doesn't get missed, is guidance from Department of Housing and Urban Development a couple of weeks ago on not just application fees, but also other sorts of fees, late fees, for example, other charges for vendor fees, a restatement of HUD's guidance for its assisted programs, both the voucher programs, public housing, as well as the multifamily assisted programs. So the link will be here in the document that we send around. It's on the PD&R section, the data research page for HUD. And to the degree that you're reviewing your late fee and other fee policies for assisted residents and assisted properties, I encourage you to take a look and make sure you're square with this new guidance from last month. Next slide, please. Okay, applicant fraud. Clearly one of the top line stories of the last year, at least, and one in which new products are helping housing providers fight back against better technology on the fraud creation side, and the increasing online use of an online transaction in order to apply and move in. So a recent study by the National Multifamily Housing Council found widespread increase in all kinds of fraud, fraudulent ID, fraudulent documentation, employment and payment documentation, or paycheck information. And importantly, the prevalence of this isn't well detected at the front end of the screening process, that a quarter of bad debt and evictions at the back end of the housing process, the life cycle, are traceable to applicant fraud on the front end. And I know, having represented collection firms and others in the space that spend some time, that an allegation, true or not, of identity theft or fraud is increasingly common as a way for a consumer to try to avoid the obligation to pay on a rental debt. And that's often valid and often just a story. So it's important to manage in this area, to look both at products that help protect against fraud in documentation, as well as fraud in the identity of the consumer. Buying an online identity for a few $100s that is a fraudulent identity is fairly inexpensive, fairly popular on TikTok and places like this. And increasingly better tools are needed by housing providers in order to mitigate that risk. I think the one operational question to talk about here briefly is just, what do you do where the application cannot meet the identity verification requirements? Different products handle this in different ways, But in some cases, you may find that the problem is not, in this case, fraudulent documentation, but maybe a bad image or other information that's used in the process. What we recommend is where there's an initial failure of the identity verification, that either the applicant is given another chance to retry and get a better image, to get additional identification, a government issued ID, or is referred to the property to attempt to apply face to face. And this is really to make sure that this is a true fail in the identity verification and not a mistake in the way that the image is captured in the process, in an online process. Often what we find is where the fraudster is involved, that they never come back after this process, and where it is somebody who's well-meaning, has appropriate ID, but mistakenly has failed the identity verification. They're able to get that sorted out either by retrying the online transaction or by going to the property. So something to keep in mind as you look at smoothing this process in the IDV process. Next slide, please. So credit and income qualification here compared to even just 5 years ago, with greater use of open banking in this country. What was typically a trade line in a consumer report used in a score to evaluate tenant lease default risk has more variety today. And so consumer permissioned account information, where a consumer will go in and provide rights to access their account information to a facilitator and to get current payment information, account balance information, income information that might be scored or might be used in some sort of rule of thumb to evaluate creditworthiness. Both of these approaches are being used fairly commonly in the tenant screening marketplace, just as in other aspects of consumer financial services marketplace. We also see that decision models in the housing space, we continue to see common use of scores for predicting lease default, but also rules of thumb, income to rent ratios, and other traditional methods that are used as decision models. I think the things to watch for here are some of the limits on scores and on even income used in qualifications, especially where a voucher may be involved by the applicant. So here, take the first case of Washington, D.C. and Philadelphia, two, but not the only two jurisdictions that do not permit the use of score to decline a consumer in the tenant screening process, but do permit the factors that go into a tenant screening score to be used as the reason for adverse action in a case. This is sort of a compromise situation, one which we've seen in other jurisdictions in the Midwest as well, and one where we see that there's the prospect of other legislation to address this concern over scores used in the tenant screening process. The other limit that I mentioned on income, Colorado sort of leads the way here. And this is that the income may only be considered for a limited purpose under the statute, to see if a person has twice the rent they need in order to meet the terms of the lease. That's the only use that for an individual applying in Colorado that the state allows. So wider use of income, variations in income to rent ratios are limited under the Colorado model. And we're watching to see if that approach works in other states as well. The one issue I wanted to touch on is the source of income issue as it relates to tenant screening. It's one where HUD has increased awareness on source of income jurisdictions already. It has funded testing and education efforts around source of income and been a real advocate for for non-discrimination against consumers who bring some kind of voucher or other sort of subsidy to help pay a portion of the rent. I think the key action items in the background screening space are to make sure that the vendor tool appropriately is only looking at the risk related to the tenant's portion, the tenant responsible portion of the rent, because in the view of advocates in and outside of source of income jurisdictions, the consumer's ability to meet the terms of where a voucher is involved, the voucher is going to cover a certain portion, and there's no resident risk. There's no reason to look at credit history and score in the view of advocates in that space. So the operational issue, I think, is to make sure that in the training process, your leasing staff are applying the rent inputs and the tenant income appropriately where a voucher is involved, to make sure that a individual with a voucher really can apply and qualify for a unit where they're only paying a small share of the rent and the rest is covered by the voucher. Next slide, please. Okay, we talked a little bit about credit and typically an income information. So private data shared with permission by the consumer in the application process. We want to talk also about public records. I think that the key consideration here and some of the exposures that this creates for housing providers is the fact that these come out of state laws that vary significantly. These come out of jurisdictions where the method of obtaining the information varies greatly, and typically they both criminal records as well as rental history records don't always have the identifiers, the personal identifying information that's available for comparable credit information in the private process. So why is this important what does this mean operationally for the property manager? I think the punchline here is that as we look at litigation in the space, it's not uncommon to see common names of consumers, applicants, rental applicants, where the screening transaction is run on the individual with a common name, comes back as a mismatch, and in looking at dozens and dozens of these litigation matters, some of which can run into the hundreds of thousands of dollars to resolve on the part of the housing provider or the vendor. One of the learnings, one of the takeaways is that incomplete name information has been included in the query. And so to determine whether this is one James Rodriguez or another in a particular jurisdiction is very difficult. So the punchline operationally is pretty mundane, but important to limit the risk of litigation and mismatch on public records. It's important to have middle initial and date of birth information, as well as full name information in the initial application query in order to get the narrowest, most accurate set of records back in the process. And then similarly, the related issue for the housing provider who has the obligation to take adverse action on this information is to make sure that you've reviewed the information in the report and it does match against the applicant that you're considering. That there's always going to be information the housing provider has access to that the screening provider does not, that can be used to properly identify the consumer in this process and make sure it's the right person about whom the decision is being made. So that's one about accuracy in matching the right name, particularly with common names. I think the other areas the second area goes more to the fact that for both rental history records in the civil courts as well as criminal history records, that sealing and expunging records is more common, that increasingly some states are time limiting the period by which a eviction court record will be visible. And then after a certain number of years, maybe 3 years, 4 years, 5 years, it would disappear as an an automated operation. So it's important to be alert for consumers who come in to dispute information saying that that record doesn't exist about them anymore, or relatedly, they were told that that it would come off with the court, but the court hasn't removed it yet, and the applicant has information to demonstrate that. So this dynamic is one that tenant screening providers are on top of and are spending some time on, but it is something where the ability to expunge and seal the record on an automated basis will continue to increase in frequency around the country. The CFPB has come up with heightened accuracy expectations for the screening reports that are used in this place. Typically, in some of the settlements, they insist that no filing information can be reported, but that only judgment information, a small subset of all eviction history, can be reported under some settlements that they've reached in these cases. So we are seeing less eviction record history information as a result of these kinds of settlements. That's on the screening provider. I think the related issue for housing providers is that we are in the early stages of looking at a couple fair housing cases, one a HUD complaint, the other a private advocacy group lawsuit involving housing providers that have a policy to automatically decline on any prior eviction. And this is viewed to be discriminatory on a racial basis, and there are more narrowly tailored solutions that advocates are encouraging housing providers to adopt. So, for example, the housing provider who limits its declines in coming up with its decision criteria to only eviction judgments and not any filings is going to be less likely to face a challenge such as the ones that some housing advocacy groups have begun to bring. Similarly, the housing providers that we work with, some of them are adopting a de minimis tolerance where an applicant has a smaller prior judgment or amount that's owed in the rental process for a prior rent debt that they have or prior judgment. If this is a de minimis amount, it's possible that that would not be grounds alone for disqualification in the screening process. So we don't have time to go into today, but I would encourage you to check the local laws for limits on the use of eviction information in your jurisdictions. Next slide, please. With that, let's turn a little bit to criminal history and sex offender records. And here, I think the general theme is that we're moving away from the bright line rules, the old school rules for some that no felony was admissible. An individual who had a prior felony was in no case admissible. Moving away from that world to one where individualized assessments with more narrowly tailored criteria based on the age of the crime, how far long ago it happened, and often based on the type of the crime, are more common in tenant screening criteria that we see. I think the key recent document here is HUD's guidance from 2022. Those of you who follow the space know there's also some earlier guidance in 2016, which is also useful from their Office of General Counsel. But their guidance to from the Fair Housing Equal Opportunity Office in 2022 has these best practices for housing providers that are worth repeating here. In the review of an individual's prior court history, having a written policy that's supported by reliable evidence of drawing the criteria, some relationship between the screening criteria and the risk to persons or property is important in developing a screening policy. HUD encourages that housing providers not consider a criminal inquiry until after they've determined that an applicant is qualified in all other ways for credit and so forth. And then in reviewing the criminal history, to consider the nature, the type of the crime, the severity of the crime, whether it's a felony or misdemeanor, and the recency of the criminal conduct. And I think in particular, the recency of the criminal conduct, we'll talk about this on the next page. We see some research showing that the age of the individual and the age of at the time the criminal conduct occurred, and the how long ago it had happened, both of those go to recency, are important factors in evaluating the likelihood that that particular applicant would commit a subsequent crime. So the nature, severity, and recency of the criminal conduct as against older criteria, which would not differentiate among the age of the crime or the severity of the crime. Procedurally, HUD recommends providing a record to the applicant before taking adverse action and giving them the opportunity to provide mitigating information to explain, for example, a clean rental history they've had in the 7, 8, 9 years since the criminal conviction, and evidence that they, for example, have maintained a job or gone through rehab or so forth, that this individual mitigating information in HUD's eyes, in some cases may be enough to qualify an individual who has an otherwise disqualifying record on criminal criteria. Similarly, this gives the opportunity to dispute the currency or accuracy of the record before the housing provider takes adverse action based on it. So the local rules that expand on this general federal HUD fair housing guidance for criminal history screening can vary quite a bit. And typically in these jurisdictions, and some of them are listed here, this is a partial list. The common components are that an inquiry asking about criminal history before the individual is otherwise qualified is prohibited. That this is, if you will, a two-tier, two-step process, and the initial application should not have any questions about criminal history of the applicant, but instead some sort of written offer, a conditional offer, typically a short letter, electronic communication. In some cases, some jurisdictions, actually a conditional lease has to be delivered to the consumer before the housing provider can evaluate the criminal history of the applicant. There are limits on the kinds of criminal history that can be disqualifying. Several of these jurisdictions enumerate a long list of offenses that may be disqualifying. The one in New Jersey goes on for about 12 pages to describe how far back in one's criminal history a housing provider can look, depending on the type of the offense. Again, following, but putting some more specifics around the HUD advice, considering the mitigating information the consumer provides. There may be an obligation for the housing provider to give notice to the consumer about this, to give a certain time period where the consumer can appeal the process, can appeal the decision. Check with your local law to see which of these may apply in your jurisdiction. Next slide, please. You know, one of the things is a question we get fairly frequently is this idea of reliable evidence for setting criteria. And so we wanted to share some of the recent research that's been in comment letters to the federal agencies about the background screening area. Some of the challenges here are that there's not a lot of consensus in the criminal history that helps housing providers set clear, bright lines. So working with experienced counsel is important. But one question we get goes to the look back period, how long back a housing provider may look in order to look at the likelihood that a prior conviction may suggest a subsequent arrest for other criminal activity, may threaten the property or threaten residents. And I think the thing here is that under some of the Department of Justice studies and the U.S. Sentencing Commission studies, there's a fairly high rearrest rate for violent offenders or those offenders who are in prison over an 8 or 9 year period. I think, as you see, 83% of prisoners are rearrested in the following 9 years. Under the DOJ study, 64% of the violent offenders were rearrested in the following 8 years under the Sentencing Commission study. So there is an opportunity to look back for a fairly long period of time. But I think there's more skepticism and question about looking back 20 and 30 years for felony convictions and using that as a grounds to decline the applicant. That those may be harder to defend, although there is not a specific guideline or number of years that either HUD or any sort of research organization put out to follow in this case. As I mentioned before, the person's time since the last conviction, the age, and the number of the convictions are the most reliable predictors of the risk that the individual will reoffend. And so in looking at the criteria that an operator would use, we see that many housing providers will draw a distinction between misdemeanors and felonies, looking back for a longer period of time for felonies, and in particular, looking at those kinds of felonies against person or property, and potentially treating those as disqualifying when comparable offenses against society more generally may not suggest a risk today that person is going to commit another crime against property or person. Similarly, the other area to look at here is to validate that the conviction you're declining on is indeed still illegal today. And we've seen some challenges where a consumer may say that if this is a drug possession conviction, that they're eligible, maybe they haven't gone through it yet, but they're eligible to have that conviction pardoned or even expunged. Maybe they haven't gotten around to it, but the fact is that the conviction relates to activity that would not be illegal today under that state. So these are a couple modifiers to keep in mind in crafting a look-back period and appropriate categorization of crimes to make sure that you're evaluating comparable histories in a comparable manner across your portfolio. So 4 things to keep in mind in applying the decision criteria. 5 things to keep in mind in applying the decision criteria. 1, be aware of the fact in looking at a violation that multiple sources may go into the same conviction, that a court, a Department of Correction, and the sex offender registry may all relate to one event, one activity, and one conviction. So in setting your criteria, make sure that this violation is treated as one violation and not 3. Recognizing that multiple sources may relate to one activity. Second of all, as I mentioned, make sure you're matching affirmatively based on the additional information that you have as the housing provider, the consumer, especially one with a common name, before taking adverse action. Make sure and review your process from time to time to make sure that the individualized assessment, your consideration of exceptions, if you will, of mitigating information is applied consistently across your portfolio. We encourage, our clients we work with to do a review periodically to make sure that you're indeed declining on the types of criminal history that you think you are, and that you're applying the exceptions and review of mitigating information in a way consistently across the portfolio. Reviewing your record with the help of counsel can really help make sure that you're following a consistent process in practice. And then finally, make sure that you're communicating clearly to the applicant what your appeals process is. Typically, there's not an obligation to hold open a particular unit for a particular period of time. Often the housing provider is the one who sets the time period in which the consumer has to offer additional information if they're objecting to a decline. So make sure you're clear about that process, that you've communicated it to the consumer, and then that you're promptly responding to an offer of additional mitigating information from the applicant. So let's, from there on public records, let's turn here on the next slide and look at portable reports. So portable reports, the concept here is simply that the consumer can bring their credit history or provide it through a third party to a housing provider. And it's a relatively small number of states that address this, have legislation to address this. But we are seeing, because of the work of some of the independent listing services in this place, in the space, and some of the tenant screening products that are in the market, that the consumer has the ability to push to the housing provider their report. And it is a reliable, accurate, relatively complete report that is delivered in such a way that the opportunity for fraud in the application process is pretty limited, i.e. it's pushed by the consumer through a screening provider or through some other sort of technology provider, and is maintained, the accuracy is maintained such that it's a complete and up-to-date consumer report. And that's a lot different than some of the concerns and some of the realities that we've seen in some jurisdiction, where the consumer comes in with a handwritten printed report, and it may appear to have some changes on it, may or may not be able to replicate the report. And that is sort of the concern of that opportunity for fraud with that sort of self-provided hard copy with, maybe with some changes to it. That kind of portable report really appropriately raises some fraud concerns in the application process. So the punchline here, I think, is, given the variety of products in the market and among the ILSs, the independent listing providers, their ability to facilitate some of these transactions, screening providers, their ability to deliver a product in the market, and just the growing diversity of solutions in the space, I'd make sure that your policy, your criteria addresses whether or not your properties will accept, under certain conditions, these kinds of portable reports. And I'd encourage you to think about it, what your approach is, and address that in this written policy. Whether or not your state has a specific statute that addresses portable reports. We're seeing that the business is running ahead of the legislatures in this case, and the benefits to the consumer in that they can provide the same report multiple times across multiple properties are significant to reduce some of their costs in the screening process. So it is typically not required that a housing provider accept a portable report, although many do. And I think the punchline here operationally is to make sure that you have a policy, and that to the degree that you are reviewing a portable report, that you make sure that it is complete, that it's covering eviction and credit and criminal history, that it's current, let's say within the prior 30 days. And typically that there's some certification from the applicant, a representation that it hasn't been modified in being provided to the property. Ideally, and this is permissible in nearly all states, you might have a requirement that it is provided by a screening provider or other entities, such that it's not being brought directly by the consumer to the property. So review your process and make sure, as you train, that you've got a sense for your leasing staff of how to handle these kinds of portable reports as they come to your properties. It's not, given the prevalence of the business, it's not just limited to those states that have passed laws that address this phenomenon. All right, two more topics, and then we'll open it any questions that people have here. Disputes and reinvestigation. So this is important one for the federal agencies in particular, and this goes to in particular, information data that may be furnished by your organization and then used subsequently in the tenant screening process or other kinds of credit processes. And the key point, I think, for housing providers is that where there is an inquiry either from the consumer who says, hey, you're reporting some prior rent payment information about me and I'm wishing to dispute it. They're coming to the property directly or coming indirectly through maybe a collection agency that's doing work on your behalf as a prior resident, or through a consumer reporting agency like Experian or TransUnion or Equifax or other screening providers in the space. That you have as a property management company a clear process with good training about how to conduct the reinvestigation of this consumer dispute. The topics, there are a few of them that recur quite frequently. Identity theft is a common allegation. As I mentioned earlier, sometimes they're very valid grounds. And in other cases, this is purely an attempt to get out of a debt and try to improve a credit score through artificial means. And the data that you have, the prior lease information and so forth that you may maintain is going to be important to helping resolve which case this is. Questions over the accuracy of public record information are also topics that show up in the dispute process. And then similarly, charges are issues where an amount that's owed may be reported in the credit reporting process. And the consumer alleges either that they had no notice of such a charge, or that they owe this information, or that the charge was unlawful under applicable landlord-tenant law. Again, the documentation that you maintain, particularly on ex-residents, can be important, and the need to promptly respond in the reinvestigation process is important for property managers as they're furnishing information about prior rent payment history. Last slide. To wrap this up, what I wanted to hit on here were some of the themes here that drive litigation exposure. And here there are seven issues for housing providers to watch for. The accuracy in following local rules. Again, as you enter a new jurisdiction, make sure you're up to speed on all the ins and outs of these local rules that we've talked about today. Secondly, make sure that there's in running a screening transaction that you've got complete PII about the consumer, and you're putting that in to accurately identify who they are. Third, applicant fraud is a business reality, continues to grow. We're in an online dominant transaction. Make sure that you have good mitigation steps in place to limit your exposure to fraud. We're finding that there's more fraud than we realized when we get to the collections and evictions process. Fourth area, consider income and vouchers. Make sure that your process appropriately protects those whose source of income may not be standard income information, and that your staff are educated on how to apply the tools that you have to properly screen a voucher holder or applicant with some kind of subsidy. The fifth topic is look back and review the application, and as you review and decide, make sure that you've got a consistent process to review the appeals or disputes or opportunity to present mitigating information, and then adjust your criteria as you need after you've reviewed this with counsel on a privileged basis. And I say this importantly because often we find that a housing provider may not be fully aware of what's happening region by region by region without this kind of periodic review of policies and how they're being carried out. And finally, the last bit, particularly as it relates to derogatory information that you may be providing to the credit bureaus, perhaps through your collection agency, is making sure that you're reinvestigating disputes as needed in order to validate a debt, or respond to questions about identity theft in the dispute process. And those are key sources, all these key sources of potential litigation. Here are 7 steps to help reduce your exposure in that process. So, Joe, those are the key items I had today.
Well, thank you very much, Jay. Really appreciate you taking the time to share such a deep understanding of the rental housing resident screening space.